Please note that the information within this video series on the Mental Health and Wellbeing Act 2022 is not legal advice. We'd also like to let you know that the content in these videos has been checked and approved by the Victorian Department of Health's Legislation and Entities Oversight team. Hi, and welcome to the third video in Tandem's video series about the Mental Health and Wellbeing Act 2022. This video is about the Act's decision-making principles, compulsory treatment, and restrictive interventions. It is also about the ways that consumers' rights can be protected and about the health-led response. I'll briefly explain some of these terms for anyone who isn't familiar with them. If someone is receiving compulsory treatment, that means that a treatment order or temporary treatment order has been applied to them, and therefore certain hospitals or mental health clinics can provide treatment whether or not the person wants it. And restrictive interventions include when someone is placed in seclusion or bodily or chemically restrained. Seclusion means that a person is confined to a room on their own and they are not free to leave. Bodily restraint means a person is prevented from having free movement of their limbs. And chemical restraint means that a person is given a drug for the primary purpose of controlling their behaviour by restricting their freedom of movement. This is different to being given a drug as medical treatment. And the term health-led response means that responses to mental health crises and the transport of people with mental illness are led by certain mental health professionals rather than police. I want to acknowledge that these topics can bring up distressing memories for many people, and also that people watching this video might currently be experiencing a very stressful situation. So I'd like to revisit the slide that we had at the start of video 1, where I explained about various free support services that are tailored to family, carers and supporters of people with mental health challenges. These services aren't crisis services. A list of crisis support lines that are open 24/7 can be found at the start of video 1. If someone's life is in immediate danger, please call 000. As video 2 explained, the Act has a set of 13 mental health and wellbeing principles. A few of these principles are particularly relevant to the topics I'll discuss in this video, so I've included them here on this slide. The Act aims to have these principles inform the mental health and wellbeing system's approach to people's rights, including to promote the use of voluntary mental health treatment over compulsory wherever possible. The first principle there is about respecting and upholding a person's dignity and autonomy. It says that the rights, dignity and autonomy of a person living with mental illness or psychological distress is to be promoted and protected, and the person is to be supported to exercise those rights. And below that on the slide, the dignity of risk principle explains that a person should have the right to take reasonable risks, and that being able to take reasonable risks is important for personal growth, self-esteem, and quality of life in general. The principle also acknowledges that this can involve a balance, whereby services may need to balance dignity of risk with the duty of care they have. And the last principle on the slide there is the least restrictive principle. It explains that mental health services should be provided in a way that minimises, as much as possible, any restriction of a person's rights, dignity and autonomy. It says that service provision should therefore reflect the views and preferences of the person as much as possible. It also acknowledges that this approach is conducive to recovery. The Act also has a set of decision-making principles. The purpose of decision-making principles is to guide the thinking of practitioners and the mental health tribunal when they're making decisions about compulsory assessment, treatment, and restrictive interventions. As you can see, they have the same kind of intentions as the mental health and wellbeing principles on the previous slide, but the decision-making principles are more specific and detailed. I'll give a very general summary of these decision-making principles, and the full text of these principles themselves are here on this slide and the next. They acknowledge that compulsory assessment and treatment and restrictive interventions significantly limit a person's human rights and may cause serious distress and disruption to their relationships and other aspects of their life. These principles also state that these types of measures should not be used unless the serious harm or deterioration to be prevented is likely to be more significant than the harm to the person that may result from their use. Also, these types of measures should be provided with the aim to transition the person to less restrictive treatment, and the will and preferences of the person should be upheld as much as possible. The 2022 Act requires that a person who has authority to make a decision or exercise a power regarding the care or treatment of a patient is to give proper consideration to the decision-making principles when making that decision. I'd like to provide some explanation about compulsory assessment and treatment. I'll briefly step us through the process of moving from compulsory assessment to a temporary treatment order to then a treatment order. An assessment order is the first step in initiating compulsory mental health treatment. Under the Act, an assessment order can be made by a registered medical practitioner or an authorised mental health practitioner if they have examined the person within the last 24 hours and determined that they have met the criteria for a compulsory assessment. In determining whether the compulsory assessment criteria apply to a person, the registered medical practitioner or authorised mental health practitioner must consider information communicated by the person being examined and may consider any other relevant information, including information communicated by any other person, including family, carers and supporters. If an assessment order is made, it enables an authorised psychiatrist to examine the person without the person's consent to determine whether they have mental illness and need compulsory mental health treatment. Assessment orders can require that the person is assessed either in the community or in the hospital if the person cannot be assessed in the community. Depending on whether the assessment needs to occur in hospital, assessment orders generally last 24 to 72 hours. Once a person is examined by an authorised psychiatrist, the authorised psychiatrist can issue a temporary treatment order if they are satisfied that the person meets the compulsory treatment criteria. I'll read through this criteria shortly. A temporary treatment order, or a TTO, authorises the provision of compulsory mental health treatment. The order can require that treatment be provided in the community or in the hospital if treatment cannot be provided in the community. A temporary treatment order expires 28 days after it is made. Also, the authorised psychiatrist must revoke a TTO if they determine that the person no longer meets the compulsory treatment criteria. The Mental Health Tribunal then decides whether a person will receive further treatment. It must decide within 28 days whether or not to make a treatment order. This would be either an inpatient treatment order, ITO, or community treatment order, CTO. An important change that occurred with the 2022 Act is that the maximum duration of treatment orders was reduced from 12 months under the 2014 Act to 6 months, or 3 months if the person is aged under 18. The tribunal can also decide whether another compulsory treatment order can be made when a current order is expiring, A community treatment order can be changed to an inpatient treatment order or vice versa. A temporary treatment order or treatment order can be revoked, ended, and if compulsory electroconvulsive treatment, ECT, can be given. The Mental Health Tribunal is independent of mental health services. There are 3 tribunal members at each hearing who are a lawyer, a psychiatrist or a doctor, and a community member. Hearings are confidential, closed to the public, and less formal than court hearings. We have here on the slide a still taken from a video that explains more about the tribunal, which you can find on their website. The address is www.mht.vic.gov.au. And I'll talk about the tribunal in relation to family, carers and supporters shortly. Here on this slide, we have the ACT's criteria for compulsory treatment, which means either a temporary treatment order or a treatment order. The criteria are that the person has mental illness, and because the person has a mental illness, the person needs immediate treatment to prevent serious deterioration in the person's mental or physical health, or serious harm to the person or to another person, and if the person is made subject to a temporary treatment order or a treatment order, the immediate treatment will be provided to the person, and there are no less restrictive means reasonably available to enable the person to receive the immediate treatment. In deciding whether the compulsory treatment criteria apply, the authorised psychiatrist must have regard, to the extent that is reasonable in the circumstances, to the person's views or preferences expressed in their advance statement of preferences or by their nominated support person, if applicable, the reasons the person has those views and preferences, including any recovery outcomes they would like to achieve, the views of the person's guardian, if they have one, the views of any carer, if the authorised psychiatrist is satisfied that making a temporary treatment order will directly affect the care relationship, the views of a parent of the person, if the person is under the age of 16 years, and the views of the Secretary to the Department of Families, Fairness and Housing, if the person is subject to a relevant child protection order. On the topic of compulsory treatment, I'd also like to mention that there may be changes made to the legislation in future. An independent group was commissioned to undertake a comprehensive consultation process to advise government on how Victoria's compulsory mental health assessment and treatment provisions could be reformed, and how mental health decision-making provisions could be aligned with other decision-making laws. If the legislation is amended, Tandem will update the content in these videos accordingly. Under the Act, restrictive interventions are only permitted in certain circumstances. Restrictive interventions can only occur if it is necessary to prevent serious and imminent harm to the person themselves or someone else, or if bodily restraint is required to enable the administering of treatment to the person, and all reasonable and less restrictive options have been tried or considered and found to be unsuitable in the circumstances. Restrictive interventions must be authorised by an authorised psychiatrist. However, if an authorised psychiatrist is not available, a restrictive intervention can be authorised by other specific health professionals, such as the nurse in charge in some circumstances. Alternatives to restrictive interventions tried or considered must be documented. Also, the use of restrictive interventions must be reviewed, and the person who experienced them must be given the opportunity to participate in that review. For further information about restrictive interventions, including what to do if you have concerns about an instance of seclusion or restraint, please refer to Tandem's Information Sheet 4 in our information kit about the Act on our website. Video 2 in this video series also mentions the responsibilities that services have around communicating with family, carers and supporters when restrictive interventions are used. I'd now like to explain a bit about the different kinds of safeguards that can protect the rights and dignity of people receiving mental health services. A number of these safeguards have been strengthened in the 2022 Act. People have many different rights under the Act, and just some examples are the right to feel safe and respected, the right to communicate, the right to have information, support and help making decisions, and the right to choose a nominated support person. Statements of rights are documents that explain what a person's rights are in certain situations when receiving mental health services. There are different statements of rights for different situations. For example, if the person you support is receiving a bed-based service at a designated mental health service on either a voluntary or compulsory basis, they should receive the relevant statement of rights. As another example, if the person you support is on any form of compulsory order, they should receive the relevant statement of rights. Under the Act, service providers are required to give a person their relevant statement of rights and to make all reasonable efforts to ensure the person understands these rights. It's also good to know that the Act requires a copy of the relevant statement of rights to also be given to a carer if the situation will directly affect the carer and the care relationship, to a parent if the person is under 16, and to a nominated support person and/or guardian if the person has one. The various statements of rights can be found on a Department of Health webpage, which we put a link to on the slide. Under the Act, people have the right to seek a second psychiatric opinion. A second psychiatric opinion is when a different psychiatrist reviews a person's treatment and may recommend changes. For example, a person may have concerns about the treatment decisions their usual psychiatrist has made, and they would like a different psychiatrist to consider the situation and give their professional opinion about it, including whether they think anything about the treatment could be done differently. For people on any form of compulsory treatment order, other than a forensic order, the second opinion psychiatrist will also provide an opinion about whether the criteria for the relevant order applies. Under the Act, the second opinion psychiatrist must consider the patient's views and preferences. It's important to note that a second opinion psychiatrist cannot actually make any of the changes that they might recommend. However, the Act says that a person's usual psychiatrist must consider any second psychiatric opinion report, and if they don't adopt any recommended changes, they must explain why, both verbally and in writing. The Mental Health Tribunal, as I mentioned earlier, is independent of mental health services, and it decides whether or not someone will be placed on a treatment order. Under the Act, an authorised psychiatrist only has the authority to provide compulsory treatment on a temporary basis before the situation is reviewed by the tribunal. Under the Act, a person under a compulsory order also has the right to apply to the Mental Health Tribunal to have the order revoked. The tribunal can be thought of as a way to provide oversight of the decisions that authorised psychiatrists make about compulsory treatment. I'll talk a bit about second psychiatric opinions and tribunal hearings in relation to family, carers and supporters shortly. The non-legal advocacy service, which is provided by a service called Independent Mental Health Advocacy, or IMA, supports people receiving compulsory assessment and treatment, or who are at risk of receiving compulsory treatment, to understand and exercise their legal rights, express their views and preferences, and engage in decision making about their treatment, care, and support. This service is free of cost. The Act establishes an opt-out approach to access non-legal mental health advocacy support for all people receiving compulsory treatment. This means that consumers are automatically offered non-legal advocacy and they can then opt out of it if they choose. I won't go into detail here as I explain more about this service in video 4. The Community Visitors Program is another kind of oversight mechanism. I'll explain more about this program on an upcoming slide. Moving on to complaints. Complaints can be made directly to a service provider. All services will have a complaints procedure. If you are unsure about what this procedure is or would like any assistance with making the complaint, the service has a responsibility to explain the procedure and provide support with it. The service may have social workers, carer consultants, and family care peer workers who in particular may be able to assist. If you make a complaint to a service and you feel that they have not responded adequately to the complaint, you can make a complaint through the Mental Health and Wellbeing Commission. You can make a complaint to the Mental Health and Wellbeing Commission about the way a service was provided, a failure by a service provider to make all reasonable efforts to comply with one or more of the mental health and wellbeing principles, a failure to provide a service, and the way a service provider handles a complaint. Tandem's information kit about the Act has detail about all these safeguards, including how they should be provided or can be accessed. I'd like to now explain how some of these safeguards work in relation to family, carers and supporters. Anyone on a compulsory treatment order, not including an assessment order, can seek a second psychiatric opinion at any time and can request this through the free second psychiatric opinion service. Family, carers and supporters can also seek a second psychiatric opinion for the person they support if they are on a treatment order and the person asks them to. A parent of a compulsory patient under 16 years of age and guardians of a compulsory patient can decide themselves to seek a second psychiatric opinion. Anyone who is receiving voluntary treatment can also have a second psychiatric opinion. However, they are not eligible for the free second psychiatric opinion service. Under the Act, a second opinion psychiatrist must have regard to the views and preferences of the patient. They must also consider, to the extent reasonable, the views of a carer if the psychiatrist is satisfied that their recommended changes would directly affect the carer and the care relationship, a parent if the patient is under 16 years, and a nominated support person and guardian, if applicable. The report that the second psychiatrist writes must also be given to these people in addition to the consumer. And if this report recommends changes, but the usual psychiatrist does not adopt any of them, a written explanation why must be given to the person and their carer if the psychiatrist is satisfied that the second opinion will directly affect the carer and the care relationship, parent if the person is under 16, nominated support person or guardian as applicable within 10 business days. Information Sheet 3 in Tandem's information kit about the Act explains how to find a second psychiatric opinion. If the person you support has a mental health tribunal hearing, they are welcome to bring you along. This can be an opportunity for you to talk about your perspective. The tribunal must give proper consideration to the Act's mental health and wellbeing principles, which includes principles about family, carers and supporters, and which I talked about in video 2. If the patient does not want you at the hearing or is unable to agree to you being at the hearing, The tribunal will decide whether to talk to you. The Act requires the tribunal to give written notice of a hearing to and consider the views of a carer if the situation will directly affect the carer and the care relationship, a parent if the person is under 16, and a nominated support person and guardian if applicable. The tribunal must also give any of these people a copy of an order if one is made. If you cannot attend a hearing, you can complete a What I Want to Tell the Tribunal worksheet, which can be downloaded from the Tribunal's website. And the link is there on the slide. Even though the form says it is for patients, their family, carers and supporters can also complete one about their own perspective. Questions that family, carers and supporters often have are, what if the person I support doesn't agree with a decision that the tribunal makes? Or what if they don't want to attend their hearing or have me attend it with them? Also, you might feel you need to tell the tribunal something privately and can't talk about it in the hearing itself, or you might not feel comfortable answering a question the tribunal asks you in a hearing. Some people can be in a situation where they're really worried that a compulsory order being revoked could be harmful. We've put advice in relation to these situations in Information Sheet 3 within Tandem's information kit about the Act. The Community Visitors Program is a way to check whether people's rights are being upheld. Community visitors are volunteers who visit certain types of bed-based mental health services to monitor their quality and safety. They inquire into whether service provision is aligned with the Act, including its objectives and principles. Community visitors can follow up on concerns and complaints raised. Consumers, as well as their family, carers and supporters, can request a visit by a community visitor. You can do this by calling the advice service of the Office of the Public Advocate on 1300 309 337. Under the Act, a complaint can be made to the Mental Health and Wellbeing Commission by a carer, family member or supporter of a consumer in relation to their experience as a carer, family member or supporter of the consumer. And in relation to complaints made on behalf of or in relation to a consumer, the Act says that if a complaint is made to the Mental Health and Wellbeing Commission by a carer, family member or supporter of the consumer, the Commission must obtain the consumer's consent to the Commission handling the complaint. There can be exceptions to this consent requirement, such as if there are formal arrangements in place, like guardianship, or if a person has written in an advance statement of preferences that a particular family member or supporter can make complaints on their behalf. The Commission may also accept a complaint where it is satisfied that the person making the complaint has a genuine interest in the consumer's well-being and there are special circumstances that warrant the Commission receiving the complaint without the consumer's consent. An exception might also be made if the consumer is a child. The Carer Commissioner, Jackie Gibson, encourages people just to phone the Commission if they're at all unsure as to whether they can or can't make a complaint on behalf of a consumer, so the specific situation can be discussed and advice given. The Act does also state that the Mental Health and Wellbeing Commission can assist family, carers and supporters to resolve their complaint directly with the Mental Health and Wellbeing Service. And on the slide there, we have the phone number for the Commission, which is 1800 246 054, as well as their email address and website. I'll talk more about what the Commission is and does in video 5. It can be useful to refer to the Act's mental health and wellbeing principles if you're raising a concern or making a formal complaint. Service providers and bodies such as the Mental Health Tribunal should be making all reasonable efforts to comply with these principles. So, if one or more of the principles are relevant to the concern and reasonable efforts weren't made, you may find it useful to explain this in raising the issue. Information Sheet 1 in Tandem's information kit about the Act has more information about what to do if you and/or the person you support are experiencing an issue with a service. If you would like support with raising an issue with a service or making a complaint to the Mental Health and Wellbeing Commission, please know that you are welcome to contact the Tandem Support and Referral line on 1800 314 325. And before we wrap up video 3, I'd like to explain a bit about the health-led response and the amendment bill. The 2022 Act requires that wherever it is reasonably practicable in the circumstances, responses to mental health crises and the transport of people with mental illness should be led by certain health professionals rather than police. Where the response cannot be led by health professionals, the actions and decisions of police and protective services officers should be informed by the advice of health professionals wherever practicable. The Act also requires that powers should be exercised in the least restrictive way possible in the circumstances. This approach recognises that often it is not necessary for police to attend a mental health crisis, and police being involved can be extremely distressing and indeed traumatic, including for family, carers and supporters. There will still be a need for police attendance if there is an actual or perceived risk of harm to any person. In these cases, then both paramedics and police can be sent. However, paramedics are to take the lead with regard to a person's mental health and physical treatment needs. A bill to amend the Act was passed in 2023, which allows more time for the transition to the health-led response, such as to enable the paramedic workforce to receive adequate training. And that brings us to the end of the third video. In video 4, I'll discuss supported decision-making, including nominated support persons, advanced statement of preferences, and opt-out non-legal advocacy. Thank you for watching.